everyone, especially all participants who have registered to the SOGICA conference. I'm really honored to welcome you to the very first session of the SOGICA conference. I mean, it's the final event, and already 4 years have gone, and it's a bit sad, but I'm really honored to welcome you to this very first session. As you know from the program, this session is dedicated to the international dimension of SOGI claims. I'm very excited to chair a wonderful panel of speakers. We have Tina from Australia, we have Denise from Italy, and we have Paul from the UK. So Tina, Denise, and Paul, thank you for being here to share with us your expertise and your different perspectives on how to ensure an international framework that can better address SOGI claimants' needs. So before I introduce you and we start the discussion, let me remind that the session is recorded until we open the floor for questions from the audience. For technical reasons, we'll let, I speak to all participants, we'll let the panelists speak first, and then we will have a Q&A session. If you participants wish to ask a question, I invite you to write down the question through the Q&A function, and I will collect all the relevant questions for our fantastic speakers with the support of our amazing facilitator, that is Mohamed, and I take the chance to thank Mohamed for facilitating this session, but also for organizing this amazing, all the technical aspects of the entire conference. And let me also thank Moira, that is my colleague of the SOGICA project. As you know, as I'm a member of the SOGICA team, and Moira led the organization of this conference. So thank you, Moira, if you are hearing us. Because of the number of participants and in the interest of confidentiality, we are not giving the floor to participants. So that's why I ask you to, and I encourage you to ask questions through the Q&A function. So let's start then. Tina will be the first presenter, followed by Denise, and then Paul. I ask you to respect the time limit so we can have a good question and answer session, and we can accept also as many questions as possible. So Tina, let me introduce you. So you are a feminist, academic and policy professional who has worked in the areas of LGBT IQ refugees and women's rights, both in Australia and overseas. Tina is a PhD candidate at the Australian National University, researching lived experiences of LGBTIQ asylum seeking and refugee women in Australia. She's co-founder of the Queer Sisterhood Project and a co-convener of the first Australian conference on LGBTIQ asylum queer displacements. Tina's presentation is entitled Silence Written in Policy, Global Compact on Refugees and LGBTIQA+ persons. Tina, the virtual floor is yours. Thank you.
Thank you very much, Camilla, and thank you very much everyone for joining this session today. a warm welcome from a rather cold Australia at the moment. We're just in the middle of winter, so I really I'm jealous for, I guess, all of the nice weather that you're all experiencing. So I'm going to start sharing my slides and talk today, about the Global Compact on Refugees. I wanted to add just a couple of things to that introduction, that I also come from the experience of LGBTIQ forced displacement. So this presentation for me is both that personal experience, but also the professional experience of understanding and unpacking what happens in the LGBTIQ refugee spaces in particular through the policy lens. In the last couple of years, I've been part of the gender audit team during the development of the Global Refugee Compact, which really helped to shape my thinking in terms of the international policy, and also to really provide those examples in terms of silencing of those experiences that are either not seen as mainstream or sometimes seen as a little bit I guess controversial to be said explicitly in such international arenas, such as during the Global Compact on Refugees. I'm also most recently the chair of the newly formed Forcibly Displaced People Network, which is the first organization in Australia to specifically work with LGBTIQ+ asylum seekers and refugees, and also to be led by people who have experienced this particular form of displacement. So in this presentation today, I'm focusing on silence in the policy, because very often we do think of silence as this negative space, as a space where nothing else exists and it has no meaning. But to draw specifically on Wendy Brown, silences harbor those meanings. So the silence is a space that actually produces something new and something really useful for us to unpack, especially when we look at the way how, for example, power relations are formed and how we're treating LGBTIQ+ people seeking asylum and refugees in the context of nationalism, for example. So in the presentation, I'm going to talk a little bit about LGBTIQ refugee narratives to sort of set a scene what happens in general in life outside the policy landscape. And then I'll talk about Global Compact and refugees and how silencing manifests in there and what implication it has for the actual people who live through those experiences of forced displacement. If we think about the narratives on LGBTIQ asylum, we sort of sometimes have to first unpack and look by layer of those identities. So when we think about idea of people being refugees, it always comes up in a context of otherness, that those people are crossing those borders and we're trying, the states trying to somehow control that. In Australia in particular, we've seen a lot of language that was related to natural disasters. We've seen people saying they're flooding our shores. We kind of like exaggerate those fears and, like a sense of urgency at the same time. And mostly we're trying to scare those local people about all of these foreigners coming to our shores. And we can clearly trace the impact of colonialism in terms of those racial relationships. But what's important in this particular context is that very often those narratives on refugees in general are really degendered. They exist as if there is a very static refugee figure, that person who has no gender, no sexuality, who's really often able-bodied as well. And so we're trying not to distinguish that there are different groups within the idea of a refugee. And so when we add gender to the mix, what happens is that automatically the ideas of victimhood and vulnerability are assigned, because this is how women get to be seen. Refugee women also get to be seen as those who are upholding family values. And very often we're talking here about heterosexual family values. And, sort of by default, they're extending the idea to draw on Adrienne Rich of compulsory heterosexuality, that every refugee woman by default is heterosexual. She's either having a child or she's going to get married at some point and have a child. But we also see women as lacking the agency there. So those, the most vulnerable subjects that are needed to be protected. And so when we add queerness to the lens, it actually shifts the whole dynamic, because to draw on Sarah Ahmed, to be queer is to be someone who is not alive, is someone whose life is not grievable, who did not exist in those spaces. And hence those discussions and those discourses of sort of being exotic agents. We are really fascinating that LGBTQ plus refugees exist, and we sort of feel a bit of voyeurism about who they are. But also we see a lot of cis gay men dominance in the discourse, and it's rare that we see the accounts of queer women or trans people or bisexual people. And so what it does on a level of narratives is that none of those, so when all of those kind of three layers come together, none of them become those credible witnesses, those people who are able to tell the truth of their experiences, and those who are able to be seen as dominant group. Because when you're a refugee, you're an unreliable witness because you're the other. When you're a woman, you're an unreliable witness by virtue of simply being a woman. And when you're queer, you're unreliable because you are not living, you are not existing. And I think this is particularly important for the idea of international policy and most recently Global Compact on Refugees, because some of those ideas that lie behind how we see LGBTQ refugees gets to be used as justification why we can't actually openly talk about them in such spaces as international policy. So in the last couple of years, I was a part of the team whose role was to attend all of the preparatory meetings during the development of the Global Compact on Refugees, and try to influence, to audit, to make intervention, and to raise the idea that the Global Compact, which was an incredible, I guess, achievement in this space, that it was embedding that gender lens from the onset of the development of the document and moving forward into the implementation. And I think this quote in particular represents that it was all about the will and ambition of what's going to get into the compact. And regardless, I guess, the efforts that were put in, the LGBTIQ plus people who've experienced forced displacement ended up still being silenced and marginalized for a number of reasons, and still there was sort of a compromise and the divide in terms of how the language was used, who was seen as a dominant group within the compact, and who was those others with special needs. And so here where I think, for me, thinking about the Global Compact is really useful through those ideas of silences, because the fact that we do not have an explicit mention of LGBTQ refugees in the Global Compact is not, I guess, an accidental or unintentional omission. It is actually a space that creates a meaning in itself. And it's that silence and the omission tells even more about the whole policy landscape than if they were included, at least in one instance, for example. And so when we think of silences, it is really often that people think about some kind of a negative space and non-existence, right? If we are silent, we're just not saying something. While in reality, silence is a really productive concept to think through. Silence not only signals subjugation, but it can always also signal resistance when, for example, people refuse to adhere to a very dominant and accepted narrative about who they are, and they try to resist and not present themselves that way. Silence can be seen as or analyzed as connected to the question of truth in asylum cases, where, for example, in the context of trauma, it is simply impossible to voice what you've been through and you just have no words to describe those experiences. But most importantly, and for me most applicably in this particular instance, silence is a power to exclude some groups from those dominant discourses and from the formation of culture, history, memory, and significance about particular groups in the society. So when we look closer, I guess, in the context of LGBTQ refugees, silence operates on multiple levels. First of all, because we're not talking about LGBTQ refugees really often, LGBTQ people from refugee backgrounds get to be presented as an exception. So as if we have this very kind of normative understanding that there is a refugee group, and occasionally we've got LGBTQ refugees. They're the other, they're not the norm to the refugee cohort. And we're not recognizing in this case that, for example, people still can be fleeing war and be LGBTIQ, and that will influence how we have to be addressing them. We also see LGBTIQ people being sort of pushed to those groups that are seen as those having specific needs, which in some instances, of course, it's really true. But what we're not seeing happening at the same time is that inclusive response into policy, that we're not treating everybody as a homogeneous group with the same needs, but rather we're understanding how the intersectionality plays out. Silencing also operates on a level of erasure where we completely disregard those experiences. And I've seen so many times in refugee sectors as well, where people talk, for example, that all refugees are fleeing war and full stop. And we're not kind of going a bit further to really explain those different situations and to recognize the existence of particular cohorts. So in the Global Compact on Refugees, there is no mention of LGBTIQ plus people at all. They're subsumed, or rather assumed, under age, gender, and diversity. And I'm putting an asterisk here because, again, the age, gender, and diversity concept is not spelled out in the Global Compact on Refugees. On the one hand, you have to go to the UNHCR age, gender, and diversity policy to see that. But on another hand, when actually it is spelled out, and I'll show you on the next slide, that a definition of age, gender, and diversity is very confined, and it doesn't include explicitly LGBTIQ people. We also see that segregation, that again, there is a dominant group and there are those really vulnerable with the very specific needs, which is fine on one hand, but the whole question of vulnerability is also really problematic because very often it gets to be seen and interpreted as people having no agency, and thus sort of entails more implications in a way how we're going to be responding to this particular cohort. So this is the example where, you know, in the paragraph 9 on the page 3, we have this sort of a recollection of different types of diversity. We talk here about sex, language, religion, political opinion, birth, disability, or other status. And this is a very common, I guess, pathway with those topics that are deemed as sensitive, that we're not spelling it out. And some people might say, well, it is actually really useful because you can include way more groups in that other status. At the same time, for me, that other status operates as another way of silencing because we're not bringing those experiences into life. We're not saying them openly, but we're trying to sort of cover them up as if something is there wrong with this particular group of people. And so we cannot say it out loud. So in general, age, gender, and diversity appears across and throughout the Global Refugee Compact. It's in the program of action, it's in data collection, it's in women and girls section, or jobs and livelihoods to specific needs. But again, without it's challenging because, for example, if we look at the specific needs, the different dynamics isn't here, because here we are actually having a very complete list. So we're having a list that defines who are those people with specific needs, and there is even no kind of a wiggle room here at all to be able to include LGBTIQ. Of course, again, you can say, well, LGBTIQ people can fit under the survivors of torture or survivors of sexual and gender-based violence. But again, without that intersectional lens, for example, even in a space, when we create a space for survivors of sexual and gender-based violence, and you're going to have that trans person, that person can experience discrimination and oppression and violence even within that group, simply because they're studied to be persecuted and discriminated based on their gender identity. So those kind of safety considerations that are so central to working with LGBTIQ plus refugees, again, are not considered in these spaces. So if we look again at the IGD policy, I think while it's great that, you know, we can use those additional documents to then interpret that language, like what age, gender, and diversity policy means, who are those other people. I guess it is a much longer sort of pathway for people to follow through. And in the UNHCR IGD policy, LGBTIQ people sit under gender and not diversity, which also kind of raises a little bit of tension and a little bit of a very sort of limited view on what sexual and gender identity diversity could potentially mean. One of the other implications, I guess, with Global Compact, you know, given that it was accepted, I guess in 2018, 2019, yeah, is that how then the actual text without any mentions of LGBTIQ people influence what happens further. And so last year, together with my partner, I was privileged enough to attend the Global Refugee Forum as the refugee co-sponsor. And essentially, regardless the fact that, you know, this is the main work that I do and people know who I am, it was impossible to explicitly include LGBTIQ plus language in anything. And so there was, it was advised to us that if we wanted to have a poster visible at the event, it would have to drop LGBTIQ. And so the poster ended up being Refugee Women Organizing, where we were presenting specifically on the work that is done on LGBTIQ refugees. And then the event that was actually talking about LGBTIQ issues, which was the only one for the whole forum, was a side event that was sort of a choice for people to attend or not to attend. And again, for me, that was really functioning as another way of silencing, where technically you do have a choice, but also you have to really amend the way how you present your work and yourself and the group you represent in those spaces because of you know, some of the structural issues around lack of acceptance of this particular group. One of the other interesting, I guess, fun facts, when you are, I'm trying to convert this presentation into the article, and when I was researching any articles that were published in terms of the gaps in the Global Refugee Forum, Global Refugee Compact, there was not a single article that would identify an exclusion of LGBTIQ plus people as a gap. So I guess we have a really long road here in terms of the understanding that we cannot think of refugees as a cohort that is necessarily heterosexual and that is sort of very cisgender and, you know, very kind of homogenous in their needs and also in who they are. So I think, you know, as a community who is working in this particular area, we still have a lot of work to do in that space. So to conclude, I want to say that silencing, whether it's intentional, coincidental, or willful, in any of those forms, it actually contributes to the ongoing erasure and marginalization of LGBTIQ plus experiences of forced displacement. And, you know, as opposed to silence, visibility is really crucial for the survival of this group in all senses, whether we're talking about access, you know, to social connections and community, or whether we're talking about actual physical safety. So I'm happy to answer any questions at the end of the slides. Feel free to contact me via Twitter or email, and these are just the details of the Forcibly Displaced People Network if you want to get connected with us as well. Thank you.
I should say wow, because I found it really fascinating, and I really I had the same feeling. I mean, when I was reading the critics about the Global Compact and no mention of the sexual minorities, claimants and claimants belonging to sexual minorities and refugees. So, thank you, Tina, for your really inspiring presentation, and I'm sure that we can go deeper maybe in the discussion and to see how we can yeah, we can break this silence. I also, in our book, for example, in the Soljica project, the main outcome is the book based on our fieldwork. It is entitled Queering Asylum in Europe, and we addressed also this, we emphasizes the fact that these global compacts fail to recognize diversity, I mean, and the need also for at academic level to do something on this level as well. And you know, Tina, if I may, I remember a discussion that I had in Canberra at the Australian National University. There was a side event at the Parliamentary House, and they were presenting the Sustainable Development Goals. And even in that goals, there is no mention of LGBTIQ diversity. So I raised the hand and asked a question to the keynote speaker and asked him why no mention of LGBTI issues. And he answered that it was already very difficult to reach a consent among states about gender issues. So I understand, I mean, that lesson was not learned, and we saw the influence, the same kind of trend in the global compact. Let's move now to the probably only international pieces and guidance that try to break the silence about LGBT, about SOGI asylum, and Denise will indeed address the UN Refugee Agency guidance in a presentation entitled Filling the Gaps, the role of the UNSCR soft law instruments in developing the EU framework on asylum based on sexual orientation and or gender identity. Before giving you the floor, Denise, let me remind the audience that you are a PhD researcher at the KU Leuven Faculty of Law. Denise's research investigates whether the concept of vulnerability can contribute to fairer and more harmonized RASD procedures in relation to SOGI asylum claims. Currently, she works as a reporting associate with the UN Refugee Agency office in Italy, and she has also worked on strategic litigation in asylum matters at European and the international level. So, well, Denise, you can start now.
Okay, thank you so much, Carmela, for the introduction. Thanks a lot, Tina, for your presentation. It was really interesting. Thanks a lot. And I'm really glad to be here with you today. Just one second. Okay, sorry. Okay, and before starting, I just would like to specify that I will not be speaking in my official capacity as UNHCR, but just in my personal capacity as a PhD researcher. So this is my disclaimer. As Carmela anticipated, my presentation will be focused on UNHCR soft law instruments in relation to claims based on sexual orientation, gender identity, and in particular, I would like to discuss what is the influence of these instruments in building the EU asylum framework on SOGI-based claims and in shaping this framework. As we may all know, UNHCR has a supervisory responsibility over the Refugee Convention based on Article 35 of the Convention itself. And in fulfillment of this supervisory role, the UN agency has issued guidance to states and to decision makers on refugee status determination, and in particular on the interpretation of the very first article of the Convention, that is Article 1A, paragraph 2, on the element of the refugee definition. Perhaps the most important example of this guidance is the Handbook on Refugee Status Determination Procedures, that has been complemented over the years with guidelines on international protection, as we will see in a minute. Of course, I call these instruments are called soft law instruments because they are not legally binding as such, but they provide legal interpretative guidance, as I was saying, to decision makers, to governments, but also to the judiciary and also to UNHCR staff carrying out refugee status determination under UNHCR mandate. So these instruments have an authoritative weight, so to say, that is based on UNHCR supervisory role that I just told about, and also based on UNHCR expertise in international protection and in particular on refugee status determination. As such, since they provide legal interpretative guidance, they have the potential to foster consistency of refugee law. Now, moving specifically to UNHCR guidance when it comes to claims based on sexual orientation and gender identity, as also Carmelo was recalling, the UNHCR issued in 2012 its guidelines on SOGI-based claims, which superseded the UNHCR guidance note in 2008. UNHCR guidelines provide substantial and procedural guidance to decision makers and also are the result of wide consultations and discussion with states and an expert. Before these 2012 guidelines, UNHCR also touched already upon the issue of SOGI claims in its first two guidelines on gender in 2002 and in the same year on guidelines on membership of a particular social group, where the UN agency explained how in states' practices there have been two approaches to the identification of a particular social group based on the protected characteristic approach and on the social perception test, according to which, with either the two approaches, LGBTI persons may form a particular social group for the purposes of the Refugee Convention. However, it is only with UNHCR guidelines number 9 that the UNHCR provides a comprehensive guidance on this kind of claims. And I won't go very much into details on the guidelines. We can go back to that during maybe the Q&A session, but just to flag that the guidelines starts out with the importance of terminology when it comes to SOGI-based claims, referring to the Yogyakarta principles, and we will have Paul's presentation on this. Then they provide a legal analysis of the refugee definition applied to claims based on sexual orientation and gender identity. And I would say importantly, they provide also guidance on procedural and evidentiary matters, and in particular in regard to credibility assessment. That is one of the most challenging aspects of SOGI claims. Now, with this in mind, I would like to move towards the second part of my presentation and try to trace the influence of these instruments, and in particular of UNHCR guidelines number 9 in the Common European Asylum System, in the SEAS system. As we may know, the SEAS instruments contain references to sexual orientation, gender identity, and in particular today I would focus on the Qualification Directive and on the Procedure Directive that actually, as you can see in the slide, have specific reference to this matter. Most importantly, however, the EU Common Policy on International Protection shall develop in accordance with the Refugee Convention. This is provided by Article 78 of the Treaty of the Functioning of the European Union, and the Geneva Convention and the Protocol are to be seen as the cornerstone of the international legal regime for the protection of refugees. This is acknowledged not only in the recital of the Qualification Directive, but also it is often recalled by in the judgment of the Court of Justice of the European Union. Also in the Qualification Directive, there is a reference to guidance and to the value of the guidance of UNHCR when determining refugee status, and also to the supervisory role of UNHCR in the Procedure Directive, according to which UNHCR is entitled to present its views and to have access also to applicants. Now, moving a little bit closer to the analysis of these two instruments, I would go, for the sake of time, quite quickly on that, as this is part of our broader research, but again, we can go back to this during the Q&A session. The most, perhaps the most striking example of the relationship between UNHCR and the EU Asylum Framework, and how actually there might be some differences, can be found precisely in the Article 10 of the EU Qualification Directive. In this Article 10, the EU Qualification Directive adopts a cumulative approach to the interpretation of a particular social group, because it requires the satisfaction of the protected characteristic approach and the social perception test in order to identify a particular social group. This is different to what UNHCR has also reiterated in its comments, but also in its guidelines, because UNHCR is actually calling for an alternative approach to the identification of a particular social group. However, this does not mean per se that there is no influence of UNHCR software instruments in this regard, because the qualification directive, as other SEAS instruments, was developed through consultation with UNHCR. We must also bear in mind that the first proposal for a qualification directive came out in 2001, whereas guidelines number 1 on gender and number 2 on particular social group dates back to 2002, and the first guidance on SOGI to 2008. And there is a sort of dialogue between UNHCR and the qualification directive in the, for example, in the explanatory memorandum to the qualification directive. The explanatory memorandum makes reference to the need to adopt an inclusive approach to the particular social group, something that also UNHCR had made clear in its comment. And also the memorandum makes reference to the possibility of states to cooperate with UNHCR also in order to develop guidelines for gender-based claims. Another reference that I would like to discuss is the fact that, again, in the memorandum, there is an express reference to UNHCR handbook that can provide guidance to states in interpreting the Convention's refugee definition. This reference, however, is taken out in the final version of the EU Qualification Directive, and it is instead replaced by the reference to UNHCR valuable guidance in relation to RSD. Again, the fact that the reference to the handbook is not there anymore does not mean that there is no influence or there is no dialogue, because actually there is a wider reference, so to say, to UNHCR supervisory role, and the handbook is only one of the means through which this supervisory role is exercised. As I will say also later regarding the CJEU judgment, nevertheless, we have this difference on the interpretation of a particular social group. Instead, in the EU Procedure Directive, in the first proposal, there was no reference to sexual orientation or gender identity. These references, and precisely first to sexual orientation, actually were done in the amended proposal to the Procedure Directive, following a request of the European Parliament and also UNHCR comments on this point. The Procedure Directive also provides for special procedural guarantees for reasons of an applicant SOGI. And there is, as I was saying before, an acknowledgement of UNHCR's supervisory role and the possibility for the agency to present its views on individual cases. Now, I think that perhaps the most interesting interaction between UNHCR and the EU system can be seen in the relationship between UNHCR and the Court of Justice of the European Union. First of all, because of the role that the CJEU has in the SEAS framework, and also because UNHCR can put forward its views to the court through interventions and observations. In relation to SOGI claims, the CJEU so far has issued 3 judgments. I would today focus only on the first 2, on XYZ in 2013 and ABC in 2014. Now, in XYZ in 2013, we don't find in the body of the judgment any express reference again to UNHCR observations or position. In XYZ in ABC, UNHCR actually made written observations and also oral observations in these cases. There is a reference to UNHCR guidelines in the opinion of the Advocate General, but not in the text of the judgment. Now, in this judgment, the court comes to, so to say, partially different conclusion vis-a-vis UNHCR doctrine on SOGI claims. First of all, as I was anticipating before, the court adopts a cumulative interpretation of the particular social group because it adopts a literal interpretation of Article 10 of the EU Qualification Directive and reads the 2 approaches, the protected characteristic approach and the social perception test, as cumulative. UNHCR in its guidelines and also in his observation to the court did not favor an approach rather than the other, but called for an alternative approach. It is also true that the court in its judgment basically interprets the social perception test as something that is linked to the protected characteristic approach, because the court said that the existence of criminal laws in the country of origin may support the finding that LGBTI persons form a particular social group, however, based on their protected characteristic of sexual orientation. Also, with regard to criminalization and persecution, there is a difference in UNHCR positions vis-à-vis the CJEU, because the CJEU in its judgment stated that only laws that are not only in place but also actually enforced may amount to persecution when they provide for detention and imprisonment. Whereas UNHCR makes a reference to also the climate of homophobia that these laws may trigger. It is also true that, again, in its observation, UNHCR does not merely state that the existence of criminal laws per se amounts to persecution, and it will be necessary to see how they are applied in practice. Instead, the CJEU goes along the arguments of UNHCR regarding the rejection of the concealment reasoning. Therefore, a claim cannot be rejected by requiring the person to go back to her country of origin and conceal her sexual orientation. And also, the court did not make a distinction between core and marginal areas of sexual orientation, something that also UNHCR advocated for both in its guidelines and in its observation. I think, however, perhaps the most interesting example of interaction between the UNHCR doctrine and the CJEU can be found in the 2014 judgment on ABC. The Advocate General opinion actually referred to the helpful guidance provided by UNHCR written observations. In the text of the ABC judgment, there is no in-text reference to UNHCR opinions, but there is a reference to UNHCR as an intervener. And also there are a lot of points of contact between UNHCR observations and the CJEU judgment. First of all, the CJEU, for example, found that late disclosure of one's sexual orientation does not merely mean that the person is not credible, and also that the methods to assess credibility must not run counter human dignity and must respect human rights. And this is something that UNHCR also spelled out in its observations and in its, most importantly, in its guidelines. I think one of the reasons why there is such, so to say, such common views between the CJEU and UNHCR in this regard is because UNHCR guidelines number 9 are at the moment the only tool at global level that provides a comprehensive and rights-based approach to the assessment of SOGI claims. And also there is a dialogue between the court on the, sorry about that. Sorry. There is a dialogue that is based on human rights. So to move to the conclusion, UNHCR software instruments in this regard provide a sensitive and rights-based approach to claims based on sexual orientation and gender identity. There are still, of course, gaps and inconsistencies at EU level, but nevertheless, EU asylum law, also thanks to the CJEU, has taken steps to the protection of LGBTI asylum seekers. And UNHCR software instruments, and mainly the guidelines, can provide guidance in this relation, also because UNHCR can be seen as a relevant actor in this framework. I would propose, let's say, to reflect on what influence mean, because influence doesn't mean merely quotations and references in legislation and in judgment, but it is determined by several factors, such as the recognition of UNHCR supervisory role, the possibility to interact with the Court of Justice, and the consultation during the making of EU law. So to, let's say, better ensure the international standards are respected in EU law, there may be a bottom-up approach to mainstream UNHCR soft law instruments at national level. And this goes back to the duty of cooperation with UNHCR by states. And the basis, of course, must be a good level of cooperation between states and the UNHCR. Another way that can, of course, complement the first one is the one of horizontal harmonization and foresee the role of the EASO, the EU Asylum Support Agency, and the role that this agency can play in fostering harmonization. In this sense, UNHCR often get opportunity to comment on EASO tools. UNHCR is also part of the board member of EASO, and also here there can be sort of dialogue between the two agencies. So to conclude, also through these ways, it will be important to promote harmonization within a common European asylum system in accordance with the convention, also by paying due consideration of UNHCR views in view of UNHCR duty of supervision. I think I may stop here, and I will leave maybe other points for discussion.
Yes, thank you very much, Denise. Yeah, I mean, it would be very interesting also, also in light of field work, how you see the role of the UN Refugee Agency in the SD procedure, especially now that I think in Italy you will probably leave that aspect, and it would be interesting to see how the UN Refugee Agency can influence also, can have a stronger influence also in other domestic European countries. But now we move very quickly to the last presentation for this session. So we have the pleasure to host Paul Dillon. I think most of you already know him, but for those of you who don't know Paul, is fellow in international relations at the London School of Economics, is also senior advisor at the Rainbow Railroad, I think in Canada, but maybe you can correct me. And in 2019, he was appointed an inspector member of the UK government LGBT advisory panel. So of course he worked as refugee researcher, advisor for Amnesty International UK, the executive director of the UK GIG. So I think, of course, Paul's presentation is very welcome in this first session, and he will bring the discussion on human rights by looking at the so-called Yogyakarta Principle. And this presentation is indeed entitled the Yogyakarta Principles +10. So the advocacy opportunities on national, regional, and international level. So Paul, the floor is finally yours.
Great, thanks so much. And if I can start by thanking Sojika, the whole team, for delivering, or you will deliver, this fantastic conference. My presentation is a little bit different to my friends Denise and Tina. I worked with LGBTI asylum seekers, refugees and human rights defenders for 16, 17 years, and continue to ask the question of how do we create change? What change do we want to see? Do we have a movement for the rights of and respect for and protection for LGBTI people whose lives, whose safety is in danger? If we don't have that movement yet, how do we build it? What does it look like? Who's in charge? Who has access to money? Whose voice is heard? So my presentation is a series of questions, but I hope posing these questions at the beginning of the conference will be useful rather than putting them on a whiteboard at the end of it. If I can just start by acknowledging as well that this proposal was submitted pre-pandemic, and it would be artificial to discuss any of these issues without discussing the impact of COVID-19 on people on the move, on LGBTI people, on human rights and social justice and equality globally. I'll speak briefly about the report that I researched and co-wrote for Rainbow Railroad. But I just want to acknowledge at the very beginning that during this crisis in this country and elsewhere, we've seen people of colour, migrants, asylum seekers, refugees, people on the move, affected in the most profound ways. And I mention it as, in fact, my friend Shaheen Shahabalu, a political dissident from Iran, a human rights defender and a refugee, an old friend of mine, would have been with us today, but he lost his life during COVID. It's a tremendous shame because I know that Shaheen would have loved to have been part of these discussions, thinking about how to create change for others. And I think we should start off by recognising some of the losses within our community at this very difficult time. I'm not going to speak in so much detail about YP Yogyakarta Principles 2007 because I think to many it will be very familiar. A landmark articulation of how international human rights law applies to issues of sexual orientation and gender identity, its impact during that 10-year period on law, on jurisprudence, on policy in a multitude of countries was substantial. What I did notice between the launch of YP and the launch of YP plus 10 was the differing approaches of governments. In 2007, there was a very pronounced and substantial welcoming of YP by countries, by institutions around the world, straight out of the gates. Not so much the case with YP plus 10. And perhaps even those countries who were most involved in YP plus 10, like Australia, who actually funded the process, maybe took a different view as to the degree to which we were seeking to specify state obligations this time around. But I think increasingly in recent years, there's been a recognition, certainly in respect to the rights of and lives of trans people, non-binary people, and intersex people, that YP didn't quite cut the mustard and wasn't able at that time to fully address and articulate the fundamental human rights of LGBTI people, or however they may describe themselves in local languages around the world. And that led to the YP plus 10 initiative, which started in 2016 with a global call for proposals as to developments in international law and policy and how the initiative should respond during the course of the review and drafting process. I was involved in drafting the asylum obligations, which you'll note is the longest section of YP plus 10, and we specify in quite substantial detail the specific obligations of states to ensure a fair and effective process. The reason we did this, in 2007, the contribution of YP in relation to asylum was rather limited, which for the reasons that Denise and Tina have just spoken about, the development of normative jurisprudential standards came later. YP basically tells us that LGBT people have the right to seek and enjoy asylum. But as we know from multiple jurisdictions across the EU, Canada, and elsewhere, that similar trends of barriers and obstacles facing LGBTI people in refugee status determination processes at the hands of civil servants and judges, disbelief, degrading or inappropriate questions, the use of immigration detention, I could go on. I would argue that along with UNHCR guidelines, which remains the cornerstone of the international protection framework, despite the fact that it also is looking somewhat dated and lacks inclusion in respect of some of the issues I've just mentioned. But it is arguably the most authoritative enunciation of the fundamental facets of a fair and effective process. But I would also seek to emphasize the fact that going through any asylum process for any person, no matter the safeguards that might be in place or the degree to which states might observe YP+10 guidelines, etc., will remain a difficult and traumatic process for many. I have some sympathy with perhaps activists in the more radical parts of the queer community who advocate the no borders strategy. I'm sympathetic towards this, but just a few weeks ago, UNHCR released its global analysis for 2019, showing once again another year where we have reached an unprecedented number of people who have been forcibly displaced. Every year we say it's reached a level not seen since the end of World War II, and it continues to rise as a result of war, conflict, as Tina mentioned, but as a result of persecution and human rights violations. And we've reached the 80 million mark globally. And sadly, there appears, despite the compact, little prospect of political cooperation to provide long-term, sustainable, durable solutions to people on the move in all of their forms. YP+10 has already had a tangible impact on law and policy. It has been adopted, it has been referenced by courts, by tribunals, in policies. And I would urge you participating, whether you are a lawyer in practice, whether you are in civil society, to consider how perhaps it might be used at a domestic, regional or international level. It continues to be the case that only approximately 40 countries expressly recognise sexual orientation and gender identity as grounds for asylum globally, according to UNHCR. So I recognise that given that substantial barrier, there is going to be some limit as to the utility of YP+10, but we can only hope that it will have the same impact in terms of breadth and depth as YP. And I've no doubt that given the extraordinary diversity of people within our movement, of LGBTI people globally, and the rapid pace of change, that YP+20 will be coming around sooner than we know, and who knows where we might end up by that point in terms of progress and our understanding of the relationship between identity, human rights and refugee protection. I do want to flag that my work is at the intersection of human rights, international relations, and I would express particular concern about the Refugee Convention, about international institutions, and about the state of play in terms of global governance and this ever-increasing number of people who have been forcibly displaced from their homes in recent years. Next year, we will commemorate the anniversary of the convention, and it has proved to be a durable tool, long though it neglected the lived experiences of LGBTI people. Not neglected, simply ignored, invisibilized, denied. But it has evolved, our understanding of it has developed. As a former Amnesty staffer, where we were regularly asked the question by journalists, why don't countries get together and reform it, make it fit for purpose? Well, the age-old answer is you'll end up with something that's worse than what you already have. And we can have little trust in countries in the modern era, frankly, that the product that we would end up with would be more progressive, more inclusive, provide more long-term and sustainable and durable solutions than that which we currently have. So I personally feel that as we approach 2021 and we begin to observe the anniversary of the Refugee Convention, in fact, we need to redouble our efforts to protect it and its fundamental principles. During the COVID period, which obviously continues, we have seen a profound effect on LGBTI people who are disproportionately affected in many different ways, and emerging data and evidence demonstrates this. We have also seen international institutions recognize very expressly the disadvantages and vulnerabilities of people on the move. What we have seen too few examples of is recognition of the intersection, LGBTI people who are forcibly displaced. And in documenting the experiences of IDPs, refugees and asylum seekers on behalf of Rainbow Railroad, in interviewing civil society organizations on the front line, and human rights defenders who have been placed at risk during the pandemic, where countries have used the emergency law provisions as effectively a cover to crack down on vulnerable communities. I particularly cite the raid on the LGBT shelter in Kampala, and Viktor Orban's targeting of the trans community in Hungary. If I can say, especially as she's with us, one of the most striking examples globally from my vantage point has been the work of Tina and Renee in Australia. The survey providing us with rare and crucial data on the lived experiences at this time, in real time, of queer people in exile seeking asylum, your fundraiser, and the formation of the network, the Forcibly Displaced Persons Network. And as I was there in Australia for the Queer Displacements Conference last year, really an extraordinary achievement, devised by and delivered entirely by LGBTI refugees. I just wanted to recognize all that Tina and Renee have done and are doing in Australia, particularly as that brings me to my next point as to mechanisms via which we can seek to hold countries to account on these issues. It has not been the case that UPR, Universal Periodic Review, has been significantly utilized from an intersectional perspective, looking at the specific experiences and lived experiences of LGBTI people. And I think that that is an error. I think that's something that we should try to do more. And in fact, this is a point made by ILGA World in their 2018 analysis of how UPR has been utilized. It remains the case that issues of sexual orientation dominate in terms of recommendations, and there are only very few instances of intersectional issues of asylum or refugee status determination or immigration detention being raised, with Australia coming up for UPR in 2021. And I don't doubt that this is an issue already that Tina and Renee are working on, that gives an opportunity to hold Australia to account, a country that is proactive at the international level as a supporter of LGBTI equality, including with funding, does resettle LGBTI people to the country. And I visited a detention centre in Thailand just a few months ago, where a trans person was very rapidly released and then resettled to Australia, but fails LGBTI people and asylum seekers and refugees across the board with the continuing offshoring, Manus Island, etc. In addition to the mechanism, I would mention the upcoming International LGBT Conference under the auspices of the ERC, the Equal Rights Coalition. In 2018 in Vancouver, the governments of Canada and Chile and other members refused to allow refugee issues onto the formal agenda. It is not acceptable for the countries that describe themselves as the most active and the most supportive on LGBTI equality to neglect one of the most marginalized groups within our community and society. We simply ignored them and organized a side event on the margins of the conference. given the effect of COVID, given increasing numbers of people on the move around the world, we need to ensure it's on the agenda at the conference, and where best practice exists, it can be shared. A final 10 seconds on human rights defenders. I was at a conference recently where somebody mentioned there are many more refugee leaders in our community these days than used to be the case. And they're taking leadership and they're taking ownership of the movement. I actually disagree. As long as I've worked in this field, there have been LGBTI refugee leaders advocating for change. What they do face is significant barriers to that activism: access to funding, access to opportunities. The field of human rights defenders in exile is significantly misunderstood and has not been engaged with substantially. LGBTI refugee leaders are human rights defenders in exile, and we need to do more to ensure that their lived experiences, skills, knowledge, perspectives are at the forefront of this movement, which I think does exist, but we need to do a great deal more to come together, to work together to advance this agenda on the international level. Thanks very much.